or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Aaron Kizza, who was convicted by this court, is not there, and therefore the right to a fair hearing is violated. Then what would be your role here? All the lawyers who are here. If I may ask.
The human rights lawyer, Kizza Besigye, we want them to free Kizza Besigye, who was kidnapped from
when we started this session, all court members, including those in reserve, were present, and all of the members before you have been following this case, have been in court. So the fact that you are seeing one is not there, whoever is there has been here or from day one when this court started. So you cannot say that these are new members. We have an instrument appointing the members. You can cross-check. They are there and they have never missed any session when we are sitting. So there is nothing that members are changing without notes. That one also has not happened. The other aspect, I think the last one, I think the one raised by Council Panga, I will not go into it because I have already given my position. But Senior Council Karua say that me, as a brigadier to Kachungu, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my response.
May I, Mr. Chairman, remind my learned friend here that it is actually on video. You referred to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. I will apologize. But I never said so.
My question, the court members, we are ready to proceed. This case was...
for Aaron Kizza, because we noticed there was a change. If you gave us that, it will help us in the appeal you have directed us to, because we definitely will take up the issue. But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at we have looked at the Uganda, Constitution of Uganda. Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Kizza when he is in court as an advocate. And the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred and which we are going to draw your attention. If I may, I want to go over 2 or 3 of them and ask my colleagues to supplement. The first one I have indicated.
I thought you were responding.
You asked us to refer matters of interpretation to the Constitutional Court, and I am now seeking a reference to the Constitutional Court.
Madam Chairman, what a senior colleague is referring to, Madam Chairman, I think she will need to address herself on the procedure, especially on references under our rules, Constitutional Court petition and reference rules. And I don't think by submitting that she's seeking a reference from this court, that's what the rules provide. It doesn't provide that. There is a procedure that is provided for under those rules. Therefore, my Lord Chairman, I pray that we proceed with what the merits of today are, instead of going against what the rules of reference provide. I so.
And maybe, sir, on the question of whatever you have raised, I have responded. So I don't see how you reopen again. The question of jurisdiction was the first thing we dealt with before I took even a plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg we proceed, Honorable Chair. Maybe Council Kwabo was saying, calling you my Lord, Chairman. Nobody has forced you to say my Lord. Even if you say Honorable Chairman, it's okay. But even if you say my Lord, that's upon you. You cannot start challenging him that those calling you. He has not requested anybody that call me my lord. You can call him honorable chair of the court. It's okay. So I don't think even is a question worth asking him that can he respond. There's nothing to respond there.
Mr. Chairman, just before my senior colleagues come, again, just for consistency, we kindly request. Yes, Mr. Chairman.
Council, let's not repeat what have been said and answered.
I'm not going to repeat it, Mr. Chairman.
Yes.
I'm only asking that because we are many, if we could kindly follow a process whereby if a matter is raised before the Honorable Court, we understand that the role of our colleague is to advise. So we take it that when advice is issued by the judge advocate, the matter then returns to the court to make a finding so that the matter either rests or is left pending. And why we are saying so, Mr. Chairman, for example, is that there was no finality. Before I say that, otherwise, Mr. Chairman, it will appear then that if an issue is raised by counsel and the judge advocate issues advice and the court does nothing after that advice, then it means that the court is bound and subject and subordinate to the judge advocate. Why am I raising this? Otherwise, my lord, there appears to be a difference between counsel and the judge advocate. Regarding the issues raised in housekeeping, there has been no adverse position from the state. In the other setup where we work, when you don't refute, you accept. And it would appear then that the judge advocate is either coming into the realm of the state and also taking over the role of court. Why am I saying so, Mr. Chairman? There was an issue regarding the composition of the panel. And we take it, Mr. Chairman, that all the honorable members of the panel are part of the decision-making process of this court. The benefit we have is that when all of them are present, it is possible to follow the events, to look at witnesses, and come to a conclusion. It would be unfair to Mr. Karibala, for example, if he laid his evidence before me and then he's cross-examined before Mr. Chiwanuka, and then the decision is made by Mr. Lukwago. There is a break in the chain. So we kindly ask, before we go any further, Mr. Chairman, that the issue of the panel is completed. My neighbors whispered, and I'm sorry if they are wrong, that at the last sitting, your neighbor to my right, exactly, was not on the panel. I don't know why any particular member here identified only her, I don't know, but they insist that she was not on the panel. Other members before have said that there was one lady, now there are two. I think that causes a concern, and it may go back. Let me finish. So it raises an issue that if we break the consistency of the panel which constitutes the court, then the judge advocate has advised that they are following, they may be following from somewhere, we don't see them here, but we bear in mind that the interests we are representing are for the accused persons, that they themselves, no matter the decision of court, must be satisfied that the process has been fair and has played in accordance to the rules. So, Mr. Chairman, if the rules say that the members should be here, I think it's good that they are here. So that, and I think that's a simple matter. If they say the reserve members are here, I don't direct, but perhaps the court can get a center so that we are happy that they are there and we see them. I think that will sort out our issue. So I request, Mr. Chair, before, and maybe we first state the issue of the reference, that we put to finality the issue of the panel. Because again, if we make submissions regarding whatever I want to say, and the court has to retreat, or the state has to ask for a time to consider, and the next panel is not the same, we will then have to make the same submissions just so that the person making the decision hears us out. It's our polite request, Mr. Chairman.
Mr. Chairman, on the same, my whisper was not gotten by him. I didn't want to stand again. I wanted to bring it to his attention that actually the neighbor does not have a name tag, just like the others. That was our observation. It needs to be clarified. Secondly, I think my issue of parking includes access, my access as counsel, access in court. I'll be on record. I'll not come back to this court if I'm parking 1 kilometer away. Access includes me parking within the premises. I think that needs to be also clarified by this court. We need a conducive environment as counsel for the accused persons. I'll not carry a box of books like I did today, 1 kilometer away from here, Mr. Chairman.
I'm sorry, my neighbor is killing me. He says they say I should insist that the person who was sitting to your right the other day, in their view, appeared to be a gentleman. They allege it is a name Okalebo, and the collar was red. So we don't know whether the person today has not put the red part. But my lord, as you can see, it's a concern that the people hearing us out, when they are changing, there is a concern that we may not be heard fairly and squarely. It's our polite request, Mr. Chairman, that the court makes a pronouncement before we go further regarding the consistency of the tribunal. Of the panel constituting the court. I'm sorry. Of the panel constituting this honorable court. Thank you, Mr. Chairman.
It's all right, Council. Yes, the other day there was a panel here, as you have said, panel Karibu. But as you heard from Judge Advocate, we are 19 members. Well, 7 are supposed to be here, including me, and then the reserve is supposed to be behind there also listening. But maybe some could have misplaced by you. But yeah, you can see too of them there. It's that way in the case one maybe have a problem of feels, he can go out, another one coming. That's how we usually operate. Unless you add on something, but that's how we operate. Then accessing the court. Counsel, I may answer maybe from the gate here, around this premise and inside here, but outside the premise, I mean the gate, I may not have an adequate answer for that. And Cabinet?
I think, sir, what I can inform the lawyers is that this court is composed of 7 members before it can conduct business on any case of a capital nature. We have 7. There is no case arising before this court where Major Sala was not present. So we are ready for today's session, sir.
Mr. Chairman, we need to put this into context. The spirit of the rule that requires that the name be declared at the commencement of the proceedings. The spirit is very clear. And actually, it does not stop there. It requires that if there are objections to any of the members, the accused person is at liberty to say so. So if the panel keeps changing, like we have told Captain Okalebo, Lib, Kano came in just to replace the one who had been on record before without any procedure being followed. That goes to the root of the proceedings, the validity of the proceedings. And I've not had the pronouncement of the court martial, the validity of the proceedings, because it was not done at that, on the day. Actually, Aaron Kizza was summarily tried and convicted when Captain Okalebo came in. Kano Okalebo came in, When Kano Okalebo came in, there was no declaration made. And I've not had any pronouncement on the validity of the proceedings which were conducted in outright violation of the regulation that requires that you make a declaration that this is the parliament that is going to try you. So this is the whole point we are making, Mr. Chairman. So if, Mr. Chairman, we continue operating like this, then it's a negation of not only the spirit of the Act and the regulation, but the Constitution itself, which Constitution is what is establishing this very court martial. So, Mr. Chairman, we need, like, in reinforcing the submission of my learned friend, Freddy Pam, let court make a pronouncement, a decision.
Council, the culture here is, once an accused person is brought in the docker for the first time, he's introduced all members here and the members, which was done on that day. So this, our changing of position or alteration, just it is when we are proceeding, or maybe unless you are asking that where is Okalebo now? That's what you are asking.
Not only that, the validity of the proceedings, the legality of the proceedings, where a member of the panel is not introduced, because Captain Kano Okalebo was never introduced to the accused person. This is the point. All the accused persons, these ones in the dock and the Aaron Kizza, because he was also put in the dock here briefly. So Okalebo was never introduced to the accused person.
I think you could have forgotten, but that is the thing that is done on the first day when the accused persons or person appear in the dock. And they are asked, they answered, they had no objection.
And maybe sir for Kizza, let me educate the council court. On the context of court, you cannot say that Kizza was supposed to take a plea, he was supposed to be defended. There is nothing like that or when you are in context of court. Context of court, you must understand about how the whole process works. So you cannot say that the panel was not introduced to him. Those procedures don't apply.
May I, once again...
But I think you need to cross the chapter of Kizza because he was convicted and sentenced. If you are not satisfied, you know what to do on that one. I think let us that's not the part of the lawyer. So should we adjourn up to his finishes his sentence?
The guidance we are seeking from Mr. Chairman, how do we deal with this?
About the convict. The one who is sentenced, who is serving the sentence.
But he still has instructions.
So which means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are entitled to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on what happened to Aaron person happened, and he is going to take him forward. The proper procedure is not applied, then we are at risk. That's what we are saying.
I think, sir, we need to move forward.
Mr. Chairman.
We close the chapter. All matters have been
No, sir, we are closing the chapter, but what I want to tell the defense attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue...
The last one.
Yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, when at the ruling which resulted in sentencing my land friend Aaron Kizza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalebo was not present in 2024. However, he participated in sentencing Aaron Kizza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
It's okay. I think you need to give them the list, the other instrument of ours, so that they understand the composition of this code.
Whoever wants, we have our own registrar there, and they are also advocates. They are there, they are seated. Don't just think they are clerks. The major and the one next, they are also advocates. They manage our registry, which is also under my office. So you can ask anything. If it is an instrument of appointment, they have it.
Go ahead, we'll go ahead with this state.
Mr. Chairman, just the last one, the very last one. Mr. Chairman, I beg, Mr. Chairman, for your indulgence, Mr. Chairman, I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg for your
I think certain lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
But he has not allowed you.
It's a humble, I know, and
now, because if you are to conduct ourselves like that, then we may not go anywhere.
Because, Mr. Chairman, we are dealing with matters of life and death.
Since we started, you are talking, and now let's hear from these people also.
It all depends on the gravity of the matters you are dealing with. The sentence we are talking about here is dead.
Chairman,
the charges is dead.
I suggest you reign on Council Kwago, you should respect the chair and quote. Two lawyers cannot speak at the same time when you are all standing. It's very unethical.
They cannot say anything.
Council Raphael, proceed.
On the 7th of January, when this matter came before this court, I intimated to this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending this charge sheet pursuant to Regulation 66 of Uganda People's Defense Forces Rules of Procedure. It is premised on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of investigations, some facts revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer, and we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is RO 12743, Captain Dennis Ora, a male adult Ugandan, a soldier of regular forces of Uganda People's Defense Forces, and is attached to Armored Brigade. So is RO 4743, Captain Dennis Ola. Is an officer attached to Armored Brigade. And we are also adding there the count of treachery, which will be count 2, including the officer and the 2 accused persons. Those are the amendments we seek to have.
Mr. Chairman, we object to the amendment, especially before the ruling on jurisdiction. In fact, we stopped the application for reference to await the ruling on jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction, because the court has no, it's in our view that the court has no jurisdiction on these two gentlemen, and we seek that the ruling precedes the amendment of the charges, when we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague?
Council, which ruling are you talking about? Which ruling are you talking about?
On the ruling that you referred to Mr. Lukwago having argued on your jurisdiction to try these two gentlemen. There is a ruling you've been seeking to deliver, ever since we came?
From the Supreme Court?
From yourselves, from this court martial.
That was really the first thing.
The issue of jurisdiction, there is a ruling which was delivered on the same day it took place.
But he's aware he was here.
Mr. Chairman, honorable members, we have been under the impression that there is a ruling, I think on several occasions, that was supposed to be delivered. And that ruling relates to matters that were raised the first time the accused persons were charged. That matter, I think, has something to do with jurisdiction. It has something to do with the extraterritoriality of some offences and how they got here, and therefore the price of the charges. So we have all along been under the impression that there is in fact a ruling. I do recall my land friend of fire once actually was and said we are ready to proceed. But the events that have taken place since that time have not enabled that to happen. So we are keen on receiving the ruling. Mr. Chairman, that is point number one. Point number two, which relates to what my land friend has just prayed about, the amendment of charges. I am looking at the rule that he has cited on amendment. And it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributable to a clerical error or omission. And he did say that in the charge there had been reference to a serving officer. I haven't seen that reference myself in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. We must have known the name, but just refused to put it there. So I'm not sure that Regulation 66 allows him to do what he's asking to be done, to join I have even lost the name, Captain James. So I just rise on those two issues, Mr. Chairman, the ruling and then try to what my landlord is asking.
For the record, I associate myself with the submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwago, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving that ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling, and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeating this. Mr. Chair, just for recollection, it may be recalled when Senior colleague Ms Karua last hearing raised an application for an adjournment for an hour.
and court wasn't willing. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. Elias Lutale. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Kizza. So it is correct, if I recall, that it was at my request that we were granted an adjournment of 15 minutes so that we'd come back and the issue of the ruling was still in the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm, but it is correct that there was a pending ruling regarding those issues raised by Mr. Thank you, Mr.
Chairman and court members. Council Ms Karua read the regulation 66(1), but did not proceed to paragraph 2, which states that if at any time during the trial at which there is a judge advocate, it appears to the court before it closes to deliberate on its finding that it is desirable in the interest of justice to make any addition, omission, I can't even stop it. So that is the additional. I'm moving on that paragraph. So on addition by adding there, because this is.
The court is adjourned for 10 minutes.